Fazell said, my name's Matt Odgers. I'm a dental-specific attorney and just do transactional work, no litigation. So the goal is in working with a dental attorney is that if we do our job right, there usually is no chance of litigation happening. So you want to put the energy in on the front end to make sure that you understand everything and that all possible scenarios are planned for and taken care of. I started my practice about 12 years ago and was doing general business law and estate planning, and then worked with a couple of dentists and they started referring me. And about 8 years ago, I decided to go fully into just representing dentists, and it's been a fun ride ever since. My office is down in San Diego, but as Fazell said, we work all throughout California, being such a niche. Our client base is really everywhere. All right, so today I'd like to, high level, what we're going to be covering is talking a little bit about starting up a practice versus practice acquisitions. I'm going to touch quickly on entity selections, which is what type of business you're going to be forming and what's allowed under California law. I'm going to touch on the advisory team, which Scott and Peter touched on, but it's a very important aspect to make sure that everybody that you have on your side communicates with each other, gets along to get you across the goal line. And then I'm going to touch on dental leases from the legal perspective. And lastly, talk about the practice purchase process and the practice purchase agreement. And please feel free to raise your hand if you guys have any questions throughout the process. It helps me out quite a bit to kind of keep this moving, and legal is not something that is the most exciting, so any interaction is good. All right, startup versus acquisition from the legal perspective. If you're looking at starting up a practice, where an attorney can help you is with setting up an entity, getting yourself protected, shielding you from liability. Typically, that's a professional corporation. We help with the lease review and negotiation after your real estate agent has gotten through the LOI stage. If you're purchasing the practice, we can review and help negotiate the practice purchase agreement if needed. We can help set up employee contracts when it comes to hiring associate dentists. And lastly, help you protect any intellectual property you have. So if you have a unique practice name or logo, help you get that trademarked so that nobody else can use that. On a practice acquisition, it's a lot of the same services. The differences are we start with a letter of intent, and that's typically done by the attorney or your broker if you're working with a broker. We set up the same entity, professional corporations. We negotiate your practice purchase and sale agreement. We work on a lease assignment or new lease, so make sure that the real estate is secure. And then if the seller is going to continue working in the practice post-closing, which is a decision you'll have to make when you meet the seller, then we can help you with arranging an associate agreement for them to come and work back. And lastly, if you're not going through a bank, or if the bank is not funding 100% of the purchase price, then we'll help with putting together a promissory note for a seller financing transaction. All right, business entities for dentists. Really, there's 3 options in California. You can be a sole proprietor. If you're with somebody else, you can be a dental partnership or a professional corporation. LLCs are not allowed in California yet. They may be around in the future, but as of right now, you should not operate your practice under an LLC because it's not compliant. With the sole proprietorship and the partnership, both of those models do not protect you personally from litigation or claims that are made. So if you're operating that way, they're easy to set up and that you don't really need to do anything. But you expose yourself to personal liability, so we typically avoid those at all costs. And the most common form of practice ownership is through a professional corporation. You'll hear people refer to it as a professional corporation, a dental corporation, or sometimes people will just say S-Corp. But the S-Corp is just a tax election, so the actual filing is a professional corporation. And it's good practice to work with an attorney on getting your professional corporation set up. Primarily because if you go online and do LegalZoom or something like that, they typically are not up to speed on the dental specific requirements that need to be in your bylaws and the other entity formation tasks. And if any of those are missed, you run the risk during litigation that they can do what's called piercing the corporate veil and go around your corporation to go after you personally. So it's not terribly hard, it's just nuanced for dentists. So you want to make sure that your bylaws are compliant with California law for dentists. All right, the dentist professional team. Scott and Peter touched, oh yeah.
With professional corporation, I actually created one for LegalZoom, but do you think you would recommend that I do something to adjust it or to modify it?
Yeah, so, yeah, I'd be happy to take a look at it and see. The issue is that it's a good tool, but you have to know how to use the tool. And a lot of times the questions throughout their process, there's things that can be checked that don't get you to the same place. So I would have somebody do a once-over. Yeah?
With regard to the legal entity, are you going to touch on signing a lease as a corporation and what you're going to touch? I don't want to.
Yeah, absolutely, when we get to the lease section. Yeah.
Do you ever see a LP form with S corps as shareholders?
Yeah, absolutely. So when you do enter into a general partnership with another dentist, the general partnership level doesn't have any liability protection. But to overcome that, we have each of the partners enter into the partnership through their professional corporation so that even though the highest level, the umbrella, the general partnership, has no liability protection, it stops at the partner level to protect you. And with the LP, California doesn't allow for dentists to operate an LP, otherwise, which is a limited partnership, or a LLP, limited liability partnership. So the only option is the general partnership with each partner having their own S corp or professional corp. All right, so jumping back into the professional team, we touched on this earlier, but it really is a big kind of dance, and there's a lot of moving parts, and having dental specific advisors is absolutely key. You may have your local bank or your teller that tells you, we can do a loan. And every time we get into a transaction with somebody who's not dental specific, it ends up just extending the deal. And sometimes they can get it done, but even if they get it done, it's rare that we are able to close on time. And that's primarily because they start by making promises that they're unsure about, treating it just like it's a regular business loan. And then once it gets to underwriting, all of these specific nuances do come up, and they don't know about them usually until the 11th hour, and then everybody's racing around. Where when you work with a dental specific lender, from day one they know exactly what to ask, and they know exactly what to tell everybody to make sure that the loan closes on time. Second one is a dental CPA and accountant, someone like Fazell, who can really dive into the financials and do the due diligence for the practice purchase, and then also look at KPIs to tell you, once you step into ownership of this practice, what you need to change to have a healthy practice that's profitable. You may want to reach out and talk to a practice broker to help you find a practice. And remember that practice brokers, from the buyer's perspective, they're very nice and they'll act like they're on your side, but they're paid by the seller. So you've got to be, take the nice things and the advice they give you. Feel free to take that into account, but definitely have somebody on your side, like your attorney, to verify everything and make sure that everything's correct. And brokers a lot of times will come and they'll try and dictate the communication between the buyer and the seller, and that's okay. But you don't want to have them put up roadblocks that are unnecessary or that are overly restrictive. You want to make sure that the broker knows that you'll need access to the practice to be able to inspect the equipment, to be able to review the patient records. and all of that. And so if the practice broker is not allowing you to do those types of things, talk with your attorney and have your attorney talk to the broker to make sure that those are all taken care of. It's a good idea to have a practice consultant. They're going to be the ones who can dive in on the clinical due diligence and look at the practice management software, let you know what the production by percentage is, let you know what the treatment plans look like, so that once you step into ownership, you can continue offering services or improve services from what the seller had. A dental-specific attorney is, from my opinion, is absolutely necessary. If you go to a general business attorney, they typically will charge hourly, and you're paying for their learning curve. So you're going to be paying for their learning curve, and you're paying for that hourly. Our firm, we charge flat rates for the vast majority of our services, especially with practice purchases or startups. So you'll know exactly what you're paying, and that includes unlimited communication throughout the process. But if you go to even the best general business attorney, typically doesn't know dental-specific nuances, so you want to be careful there. When it comes to the landlord, they're going to be a part of the team, and even though they're on the opposing side, you'll want to have a good rapport and communication with them. You're going to want to establish a relationship with an equipment rep. They can come in and help you inspect the equipment during due diligence and prior to closing, so you know what condition it's in. And then lastly, you want to start early with a marketing team, someone like the Dental Geeks, to do an audit of what the practice that you're buying has, or if you're starting up a practice, to start thinking about ideas with how you're going to fill the practice's schedule. So talk to a marketing team early. It's one of the areas that has the potential to be expensive, but it's money well spent, because your revenue is absolutely contingent on seeing patients, and they're going to help you fill your schedule. All right, for dental office lease considerations, I'm looking at this more from the legal side once we actually get into the lease, and there's a lot of overlap from what we just had, so I'll try and jump over the things that we've already discussed. But I break it down into essential terms, ideal terms, and terms that you want to avoid at all costs. The other factor with leases that they touched on a little bit is that if you're buying a practice, most of the time you'll be taking over the seller's lease in the form of an assignment. And with an assignment, the seller and current tenant is just assigning you their exact lease. And so your attorney should go in and do a review of the lease, break down all the terms, and then attempt to negotiate to modify the lease to your benefit. And when I say attempt to negotiate, from the landlord's perspective, they're not really open to making changes. This is a lease that they've already negotiated, and if any changes that they make would be them negotiating against themselves. And so they have your seller that's already locked into this, so if the deal falls apart for the landlord, it doesn't change much. They still have their rent. But if you can have your attorney approach them in a friendly way and in a collaborative way and try and persuade them that this is going to be a long-term tenant, dentists are amazing tenants, and so you want to keep them happy, and try and get them to make some changes that could benefit you going forward. If the landlord doesn't make any changes, it's not a deal breaker, but you would just wait until you get to the end of the current term, and when the option renews, you can reopen the lease with the threat that you potentially could move spaces. And if you have your practice in a location, you know, the realness of that threat may not be there. You may think, you know, I'm absolutely not going to leave, but the landlord doesn't necessarily know that. And once they have you and have had a bit of a relationship with you being their tenant, they may be open to some of these changes. So keep that in mind. The essential lease provisions, I'll go through these quickly. Use clause, you want to make sure that it allows you to operate a dental practice. You want to have favorable assignment and subletting rights. And when I say favorable, usually The default is that the lease will say that you're not allowed to assign or sublease without landlord's consent. So at the very least, you want to make sure that it says that the consent has to be reasonable. Ideally, you would get them to say that you're allowed to assign to another dentist, provided that they have the same creditworthiness that you had without their consent and just notification. And when you're first entering into a lease, this seems ludicrous to push on, but at some point you're going to sell your practice or transfer it, and you don't want to have that provision come up and prevent your ability to sell your practice. Yeah.
One thing, just maybe an assignment, a recapture clause, and why you don't want to allow that in a lease.
Absolutely. And that'll be in the terms to avoid. A lot of leases by default will have this recapture clause that says a landlord can come and take it over if you request to assign the lease. And that's a terrifying clause, because when you go to sell your practice, I get dentists all the time that have that in there and it's outdated and they had no idea it was in there. And then they face a dilemma and saying, should I go to the landlord and say I'm thinking about selling my practice? But if I notify them of that, the landlord can say, no, I'm not going to allow you to assign it. And number two, I have the right to come in and cancel your lease. So there's some outdated terms like that that are just major red flags. So you do want to have an attorney review the lease early on. You want to make sure that you have your lease term and renewal options, that you understand them and you're comfortable with them. When it comes to the term, your lender typically is going to require that the term of the lease match the term of your loan. And that can include options. So the typical standard is at least 10 years left. So if you're buying a practice and the tenant has 3 years left on their lease and no options to renew, you want to approach the landlord and at least get 2 additional 5-year options. And I've had good experience with that. If you're working with a real estate broker, make sure that they're aware of that and that they start the conversation early to make sure that that's included. You want to make sure that it addresses signage rights, what your right is to put outside signs up, and who's going to be responsible for the cost. And then you want to make sure that the parking allocation is appropriate for the location and your practice. Yeah.
With subletting, typically is it, how does that usually happen? Is it typically the dentist would buy and own the practice and own it, and then when he sells, he or she sells it, then he or she would like sublet it, or are there some times where a dentist would like buy it without intending to own,
So.
buy the practice itself and then just lease the land itself?
Yeah, so typically where I see subletting is with a general practice that's open 3 days a week, and then they have an opportunity where they can bring in another dentist for the other 2 days a week, or a general dentist that wants to sublease one of their ops to a specialist. And so you want to make sure that, and the subleasing is not something that I typically will push too hard on unless my client has that in mind going into it. But at the very least, you just want to have a reasonable standard for the landlord to consent to that. So those are the essential. I feel these should be covered in every lease regardless. The ideal lease terms to negotiate, it starts with an exclusivity clause. And this was touched on earlier. It's amazing if you can get it, and sometimes it benefits the landlord and is a non-issue. But so it's a good thing to request. It's just not absolutely mandatory in all scenarios. If you're entering into a triple net lease where you're responsible for paying insurance, maintenance, and what's the third one? Oh, and taxes. You can request to negotiate a cap on the increase in triple net expenses. So maybe you'll have a 5% cumulative year-over-year increase. And that'll protect you in case there's any major additional expense that wasn't not typical but comes up in 1 year, that you're kind of protecting yourself from a gigantic increase. In San Diego, we have a lot of offices that are in kind of the fire zone, and they started dropping fire insurance, and so the insurance skyrocketed. And the clients that we were able to get a cap on the CAM charges, it didn't impact them too much, where the clients that didn't have that had a big increase in their insurance expense for the practice. Almost all commercial leases in California require a personal guarantee if you're signing on behalf of your corporation. So typically you'll want to sign the lease in the name of your corporation, and that's going to limit liability for things that happen in the practice, in the location. But the landlords won't allow you just to do that, because if you could file bankruptcy in your corporation and then just walk away, or you could strip it of all of its assets and again, just walk away. So the landlord wouldn't have leverage. So in addition to almost all require this personal guarantee, which says, in the event that my corporation stops paying rent, they can go after me personally to recollect that. So it's best practice to try and negotiate a limit on that personal guarantee and duration, and say for the first 5 years, if rent's been paid on time, that I'll be taken off as a personal guarantor. The fallback is to be released as a guarantor in the event that you assign your lease at the time of assignment. So a lot of these transactions, especially on the seller side, they'll sell their practice and assign the lease, but they're not released as a personal guarantor. So now they're not in the location. But if the buyer that purchased the practice decides to stop paying rent or shut down their practice or goes under, the landlord can come after you personally still for that unpaid rent. So it's best practice to negotiate a release upon assignment. And then if they don't agree to that, I would attempt to negotiate a release at the end of the current term after assignment. So if when you sell your practice and you assign the lease and there's 2 years left, you would be released at the end of that 2 years. So keep that in mind. Landlords are pretty strict with that, especially in the last 2 years, from what I've seen. They used to be a little bit more flexible, but I feel like it's been harder and harder to get a direct release as a guarantor. The next one is that you want to request the ability to make minor alterations in the practice. What this means is that by default, you have to go to the landlord anytime you make a change in your practice. So if you want to put up a partition wall, or if you want to paint or do minor updates that are not structural, you still have to go to the landlord and get their approval. And landlords, especially corporate landlords, are difficult with this, and they won't respond, or they'll say something like, okay, I'll allow you to do that if you go out and get the permits and show me the permits. And then the tenant will go to the city, and the city says, well, this isn't something that needs a permit, but we're not going to put that in writing. And so it just slows everything down, and it's kind of a nightmare. So typically we'll try and ask for the ability to make minor alterations, maybe things that don't exceed $20,000 in a given year and that are non-structural, that you can do without the landlord's consent and just with notice to the landlord. Lease terms to avoid is a relocation clause without safeguards. Some leases have a relocation clause which says that the landlord's able to move you from your space into another space. And you absolutely don't want to have one that allows them to do that at your expense, meaning that you would have to pay for the build out of the new space. So typically you'll want to negotiate to be able to terminate the lease if the landlord tries to relocate you, and that any relocation needs to be of equivalent size to the space that you're in. And then thirdly, that the landlord's responsible for paying your build out and moving costs. So high level, going through this process, leases are notoriously landlord favored in California, and they're terrifying when you look at it from the legal side and go line by line and treat it like it's a true negotiation where you understand everything and everything's fair. There's almost never a lease that is equal to the tenant as it is to the landlord. You're going to be agreeing to things that you would not agree in any other contract. So you have to go into it with that expectation. And like Scott and Peter said, you need to be reasonable with that understanding. What I tell clients all the time, great, is what would happen if you walked away from this lease and went to another location? Do you think that the landlord in the new location would agree to the terms that you're demanding at this point? And if the answer is no, then you should probably agree to the terms, even if they're landlord favored. If the answer is yes, or even maybe, then maybe talk to the other location and see if you can get them to come around. You want to avoid any leases that have continuous operation clauses. These are things that the typical standard retail lease will say that you have to operate your business. I've seen it from 8 a.m. to 10 p.m., 7 days a week, because those are written for things like renting to a Starbucks. It makes the center look bad if there's businesses that are closed all the time. So you want to make sure that the operation requirement is in line with the schedule of your practice. Transfer premiums, I'm not seeing them as much these days, but when I look at older leases, sometimes they'll say, tied to the assignment, that if you assign your lease, as a penalty, you have to pay 100% of the profit that you receive as a result of that assignment. Which means that if you go to sell your practice and you sell it for $1 million and you assign your lease, the landlord could be entitled to all of that profit. I've never seen that enforced, and when it comes up in leases, the landlords typically will say, yeah, that's outdated and ridiculous, but it's still something to look out for. You want to make sure that there's not unreasonable restoration obligations when you leave the space, meaning that if you decide you're just going to move to a new location, you want to make sure that you don't have to restore the office back to its shell condition, because that's going to be a big expense to remove all the plumbing and everything that was put in. And lastly, you want to make sure that there's not broad landlord termination rights. You want to identify any termination rights that the landlord has. So the big one being that they can terminate in the event that you assign your lease, or terminate in the event that they foreclose and they transfer the lease to somebody else. So you want to make sure that you're locked into that space for as long as the term is in all events. All right. Any questions as far as leases go? Okay, now I'm going to transition to the transaction timeline and what it looks like. So when you go to find a practice that you want to purchase, it starts by searching for practices. You can work with a broker on that. You can look online. You can go to websites like Provides and see kind of what practices are out there. But when you find a practice that you're interested in, you'll reach out to that seller and request what's called a prospectus, or additional information on the practice. And at that stage, it's still confidential. Usually they won't tell you who the seller is, and it'll just be high-level information: how many ops, what the revenue's like, might have some information on the types of insurances that are accepted. But once you've found one that meets your goals, then at that point, or while you're in that search, I recommend securing financing. So talking to a bank and seeing what you can be approved for based on your current credit, and seeing if that's in line with the practices that you're looking at. Once you've secured financing, then you're going to submit a letter of intent. And the financing at the early stage is just a broad, we're willing to lend to you personally. Once you find a practice, the bank still has to approve that specific practice for you. So there's kind of two steps from what I see on lending. So the first one is making sure that you're able to get a loan. The second is making sure that the practice's financials support the loan that you're going to get. So after you submit your LOI, you should work with an attorney to at least review it. A lot of brokers have their own templates, and they'll try and pressure you to signing their template prior to having it reviewed by an attorney. And a line I hear from every single broker is, we have 15 buyers lined up and we need your LOI today or you're going to lose the opportunity. And don't fall for that line. They may have other buyers lined up, but you should still make sure that the terms of that are good. Because within the LOI, while it's typically non-binding, it's still an uphill battle to make changes after the fact, after that's signed. And it really hurts the goodwill between you and the seller. So take a little bit of time, have an attorney review it, and make sure that the terms look good. Once the LOI is accepted, that kicks off the due diligence process, which I break due diligence into 3 areas. You have your legal due diligence, you have your tax and accounting due diligence, and then you have your clinical due diligence. And most LOIs will give you 30 to 45 days to conduct all of that. So once the LOI is signed, you'll start the due diligence process, and that's when you get all of the specifics of the practice. You can request all the financials, you can take a look at the equipment, you can do an audit of patient records, you can have them send over any contracts that you're supposed to take over. And that's usually where, if you find something in there, that you would back out of the transaction. But assuming everything looks good, then you approve it all and go into the purchase agreement and lease negotiation stage. And this is when your attorney gets most involved, is once the due diligence has been approved, or once you get a nod from the client's dental CPA that everything looks good even though it's not completed. Then you start on the purchase agreement, and typically the seller's attorney is going to be the one to do the initial draft of the purchase agreement, just as the landlord's the one who does the initial draft of the lease. And then it comes to your attorney, who will review it on your behalf and negotiate back and forth until you get a final version. Once you get final contracts done, you'll sign them and submit them to the bank. And typically the bank needs about 3 to 5 business days to do a final underwriting phase to make sure everything looks good. And then you fund and close. And that whole process, the quickest I've ever seen it, I've ever been a part of completing it, is 2 weeks, which I don't recommend. It's a lot of stress and everybody needs to be on it. But typically it's about a 45 to 90 day process, with the average being about 60 days. That gives everybody enough time to not stress too much and give the buyer enough time to make sure that everything that's in the practice they're aware of. All right, the 3 transaction documents that your attorney can help you with is the letter of intent, the purchase and sale agreement, and the lease agreement. These are really the big 3. The letter of intent when buying a practice should be detailed enough to cover your walkaway terms, things like the purchase price and payment structure, the assets that are included. But you don't want to go into so much detail that it can't be backed out of or changed. There's just a lot of terms that should be negotiated in the detailed purchase agreement. So I typically look at the LOI as just lets everybody get an understanding of when we're looking to close, what the purchase price is, whether there's a deposit or not. And then we can work out the details as we go, based on what's found in due diligence and based on what the specific circumstances are. Other things you want to make sure that are covered are transaction contingencies, how you're able to back out of the transaction after the due diligence period is completed without having to forfeit your deposit. These are things like if you're not able to come to an agreement on the lease, but you've already signed the purchase agreement, are you able to back out of the deal and get your deposit back? Or if the bank finds something and they're not willing to approve lending, are you able to back out of the deal? So you want to make sure that those are outlined. The other one, from the buyer's perspective, it's smart to try and have language in your letter of intent that the seller is not going to continue marketing or take backup offers on the practice. Some brokers push hard back on that, and it's not the end of the world if they do that, but the risk that you run as a buyer is that anytime you get to a sticking point in the negotiations, the seller's attorney, the seller, and the broker are going to say, well, if you don't agree to this, I'm just going to take it to my backup offer who's itching to do this and is going to give us a little bit more money. So it takes a little bit of your leverage out in negotiations if that's in there. Some brokers, it's a no-go, and they always want to have a backup offer. And again, it's not the end of the world, but ideally you'd want to be the only person talking to the seller while you're in the letter of intent phase. The last thing to consider, and I typically don't recommend putting this in the LOI, but I made a placeholder here just so I'd remember to talk about it, is whether you're going to purchase the accounts receivable of the seller or not. Most of the time, the purchase price that you're paying does not include the accounts receivable. And if you want to purchase it, you'll request to purchase it in addition to the purchase price. And the reason that you can have language in the letter of intent that says the parties may agree to purchase the accounts receivable, but you don't want to fix anything because remember, when you're signing the LOI, you haven't seen their accounts receivable. You don't know what the health is like. You don't know what the aging report looks like. So you may want to address it in your LOI if it's something that you really want to purchase, but I wouldn't agree to any terms at that stage until you get into due diligence and have seen it all. All right, so moving on to the actual purchase agreement. You'll hear this referred to as a practice purchase agreement, an asset purchase agreement, an APA, a PSA, but the big picture is that this is the main document that covers your protections as a buyer. And the terms that you want to include, number one is what assets are included and excluded. And high level, the assets that you want in there, or you want language saying any asset that was used in the production of income of the practice should be an included asset unless it's specifically excluded. And so a lot of times sellers will want to exclude certain pieces of artwork. If they have vehicles under their corporation, they'll want to have those excluded. And that's okay, but you want to make sure it's crystal clear. And in the body of the contract, we'll broadly list all assets. And then we also have an exhibit that has an inventory of the assets that are in the practice. And you never want to rely on a seller to say, well, I didn't list that, but I'm just going to leave it in there. You want to make sure that the list that you get is accurate and organized kind of operatory or room by room within the practice. And most of the time, the equipment rep that comes in and does the inspection will give you a list of all of the, at least the equipment. And so you can use that as a starting point. You want to make sure that the purchase price allocation is negotiated. So say that you're purchasing a practice for $1 million. That $1 million can be split up into different categories, and each one of those categories is taxed at a different rate. And so you want to have your attorney work closely with your CPA so that they can weigh in on what's going to be in your best interest. Generally, the seller wants as much of the purchase price allocated to goodwill as possible, and you as the buyer want as much allocated to equipment as possible. And the reason for that is that with the goodwill, the seller just pays capital gains tax on that, not ordinary income. And Fazell will be able to dive deeper into that. But you want to make sure that it's crystal clear in the purchase agreement that the allocation is broken down and that both parties agree to report that allocation on their taxes exactly as it's listed in the purchase agreement. You want language that discusses how to handle patient credits. These are things where a patient is either overpaid or paid and the treatment has not started yet. You want to make sure that those are the seller's responsibility and that the seller will return all those payments prior to the close or transfer that money to you so that you can do the work after the closing. You want to talk about what happens if there's a retreatment or a redo that comes in from the seller's work. And you want to make sure that it's clearly outlined that typically the way that we arrange it is that the seller has the opportunity to come in and fix the work. And if the seller declines to do that or doesn't have their license, then the seller can pay you to do that. but you want to make sure that it's explicitly covered. And then the same with work in progress. It's very rare that there's a transition where they don't have any open cases, because typically the seller's treating patients the day of the closing. And so there's going to be some open cases. And so you want to make sure that that's covered. And typically the language will say that you'll give the seller access to come in and finish up those treatments in a reasonable amount of time. The next is accounts receivable. If you're not purchasing the accounts receivable, you're going to want language in there that typically is that you'll continue to collect the seller's accounts receivable on their behalf, and in exchange, you'll charge the seller maybe a 5% admin fee of whatever you've collected for the work that you did for collecting that. If you're purchasing the accounts receivable, you typically want to negotiate a discount structure based on aging. So maybe you'll pay 90% of 0 to 30 days, 70% 30 to 60 days, and then it starts dropping a lot, so maybe 50% of 60 to 90, and then 90 plus you might pay 5% or 0. But you want to make sure that you're not paying the full amount if you are buying the accounts receivable, because there's the risk that some of that's not going to be collected, so you want to kind of bake in protections for yourself there. The representations and warranties, in my opinion, this is one of the most important parts of the contract. These are just promises that the seller's making about everything under the sun. And a lot of these are things that you won't necessarily be able to inspect or verify, so you want to make sure that a general promise is in there. These are things like the seller doesn't have any litigation pending that could impact the sale, that the seller has paid all of their employees up to date, and that they don't owe any benefits, that the seller hasn't waived co-pays. So it's a very broad list and it's very dense, but it's an important step to make sure that those are built out to cover everything under the sun. The next is covenants. Covenants is just another promise that the seller's making, and these include a covenant not to compete, and the sale of a business, covenants not to compete are enforceable, but in the employment context, they're not enforceable. So you may have heard that covenant not to compete is not enforceable in California, and that's the general rule, but it is enforceable in the sale of a business. So you typically, depending on the location of the practice, will want them to promise not to compete against you for a 5-year period within a 15-mile radius of the practice. And there's some wiggle room there with the duration and the scope as far as the radius goes, depending on where the practice is located, but that's typically what you want to see. If a seller is adamant about not having a non-compete, that's a major red flag, and you likely won't be able to get a loan approved because all of the banks will require that there be a non-compete in there. In addition to the covenant not to compete, you'll also have a covenant not to solicit staff or referral sources. So for the same time period and within the same radius typically, they won't be able to hire the staff after the closing. And then you want a covenant not to disparage. So you want to make sure that number one, that the seller's not bad-mouthing you after the close, and in return, you agree not to disparage the seller, meaning that everybody just takes the high ground. The next section is patient communications and name use. Typically, you'll want to negotiate to have a letter that goes out to all patients informing them of the transition, and you want that letter to be to set it up to where you're going to have success. So normally it's like a glowing recommendation from the seller to the patient saying, you know, I've decided to retire and move on to the next stage of my life, but I'm handing this off to this buyer who's an amazing dentist, and give a little blurb about your background so that when patients come in, they're not blindsided and feel betrayed and find another dentist. Yeah. Yeah, so the patient letter is something that's kind of fluid. It really depends on the circumstance. You may want to have the letter go out once they stop employment down the road, or you may want to send the letter out and have language saying that we've sold the practice, but the seller's still going to be around to do treatment and things like that. But you would just work that out one-on-one with the seller, whatever makes the most sense. And keep in mind the goal is to prep the patients that for whatever's going to keep them coming to the office. So however you can draft the letter to accomplish that goal is good. And then you want to be able to use the seller's name for a period of up to 1 year. When you step in as an owner, everything's going to be branded under the seller's name, the signage, the stationery, maybe the Yelp account, the Facebook. And by default, you're not allowed to use those assets with the seller's name unless you get the permission of the seller. And the dental board allows up to a year in transition for you to continue using that name, even though that you're the owner now. And that gives you a whole year to be able to start transitioning those to whatever name that you want to use. When it comes to employees, you want to make sure that the seller doesn't have any pending litigation, and that on the closing date, you want language in the purchase agreement that states that the seller is going to terminate all employees on the closing date, and that you have the option to rehire them right away. And this is something that is a bit of a shock to the employees, because normally they're left in the dark due to confidentiality. The seller's not allowed to tell them, and you're not allowed to contact them before the closing. So typically on the closing date, you have a big sit-down meeting with the seller there, and the seller informs them that the practice has been sold, and the seller will terminate them all on the spot, and so they hand them one letter that's a termination letter, and then you'll hand them a rehire letter. Now, there's not an obligation for you to rehire them, but it is a good idea, and at least keep the practice kind of moving the way that it's always been moving for a period of time. And if you decide that you want to terminate them once you get to know them and see what they're paid, you have the option to do that because most of them are going to be at will. If there's associates, you may need to negotiate new associate contracts as a new owner. But those are all kind of the high level. You just want to know that on the closing, all employees are terminated, and that as the buyer, you may or may not want to hire them back. And the last point, which is a bit of a sticky subject, is insurance credentialing. Typically, the seller won't want you to start your insurance credentialing until they actually close, because as part of the credentialing process, they would be reaching out to the practice and sending mail in your name and talking to the office manager. So that creates a gap in time in which you're able to collect from insurance companies. So you want to work that out with the seller, and it's very insurance dependent, but in a perfect world, you would be able to bill under the seller's insurance contracts for a short period of time, so long as it doesn't violate the terms of those contracts, so that there's no drop in the cash flow and your ability to keep the lights on. And there's a few workarounds with insurance, but you really want to be careful in the event that there's any government insurances, and follow the procedure that those types of insurances have in transitions. On the insurance topic, it's becoming less and less, but I'm sure you guys are all aware of the Delta Premier insurance. A lot of dentists who are Delta Premier credentialed, they get higher rates that are paid for being a Delta Premier member, but that's something that's not assignable as they've canceled that whole program. And so they can continue billing under it, but when you step in as an owner, you can't bill under Delta Premier anymore, so you're going to be receiving less money than the seller did. So if the seller has Delta Premier, you want to make sure that you factor into the purchase price whatever you want to have a discount for the amount of collections that come from Delta Premier, because the purchase price typically is tied to what your ability is to make money after the closing. And that's going to be reduced by what was in the Delta Premier. So you want to identify that and make sure that it's addressed. Yes? Uh-huh. Yeah.
Here, like, do the organization.
So, I mean, the default is usually 6 months, or, yeah, that would be kind of where we start. But I typically will look at what insurances are actually being transferred or taken by the seller and try and get an idea as to what the credentialing timing is, and then tie the timing of getting credentialed to that period. So if it's a 3-month period, then we're okay setting it to 3 months. But on that note, that's where working with an insurance credentialing specialist or a consultant who knows that and can help you get credentialed is really worth the money, because the quicker you can get credentialed, the less likelihood there's going to be a delay in your ability to start billing under those credentials. Yeah, yeah.
You mentioned that the buyer can use the seller's name on the office for up to something like a year.
Yeah.
Do you personally have a recommendation on, or have you seen like more success if they use the previous name longer, or like is there a benefit to transitioning the name earlier or later?
No, I typically recommend changing the name as soon as possible, and unless they're using a fictitious name. So this is just limited to the seller's actual legal name. And so if they have a fictitious name, normally that'll be included in the sale, so you don't have to rebrand. But otherwise, I would just remove the name and either come up with a new fictitious name to update the branding. But I usually recommend the shorter the time, the better. It's just a Band-Aid that needs to be ripped off, and usually when a buyer comes in, they'll kind of roll out new marketing, maybe do a website update, and maybe a little bit of a facelift on the practice. And so I just have them time it with that. So with the new website launch, maybe update the name at that point.
Have you seen more, is more common if it's changed name previously? Like does the buyer, do they buy the rights to that?
Yeah, so, and that's a great point. So I talked about the assets, and we all think of assets as something that's physical. But the assets also include intangible assets like goodwill, patient records, and then intellectual property, which are things like the trade name, the domain name, review websites, all of that. So that is included in the purchase price, unless in the letter of intent they specifically say, no, you're not going to get that. But almost always it's included, and that's kind of an assumption, but it's worth verifying early on. Yeah. All right, any other question? Yeah.
How much do you charge for the lease in Uganda?
So it varies on the type of lease, but
It's a flat.
yeah, so the range is 2,500 to 4,500. Yeah, and so it depends on if we're reviewing a lease in the assignment context. Sometimes we'll get leases that are 30 years old and have 8 amendments to them. And so that's a lot more work than a simple AIR lease that's boilerplate. Yeah. But the vast majority is 3,500 start to finish, and that's the lease review and then the back and forth negotiations. Yeah, start to finish. All right.